professionals. Live stream, here we are. Okay, hello, good morning, everybody. Thank you for joining us. Today we are going to talk about post-closing possession. And post-closing possession is something that we've been talking about for quite some time now. It is pretty common, but we're going to talk about today, like where we are today in this market. I brought on one of our attorneys, Vicki. I'm going to let her introduce herself. For those of you that don't know me, my name is Sabrina. I'm the Director of Digital Media and Education at Proper Title, your local Chicagoland and Northwest Indiana title agent and national commercial title agent. Vicki, good morning.
Thank you. Good morning, Sabrina. Thanks for having me. My name is Viki Katris. I am a real estate attorney. I've had my own office now since 2015. And real estate is all we do. So I pride myself in that, and I'm happy to be here.
Yay. Thank you so much for joining us. So let's dive in. Let's talk about this thing called post-closing possession. First, can you just very, very briefly explain who we're talking about when we're saying post-closing possession?
That's such a good question. So a lot of times, and in most situations, a seller can sell their home, but sometimes they don't have anywhere else to go, whether it's because they're waiting to actually put in an offer on another home because they haven't found the right one, or they're in the middle of closing on another property. And a lot of times in the most difficult situation is closing both on the same day, which can't always be achievable. So in this situation, we do what's called a post-close possession, allowing the seller to not only close on the property, but then stay in that subject property that they're selling for additional time for purposes of moving in the future. Typically, we see the turnaround time on that being like, it could be as little as a few days, and I've had post possessions for 60 plus days. So it works out in different situations.
So the seller's staying in the property, but the buyer owns it. So I'm buying a property that, let's just say I'm buying this property, and we have agreed prior to closing, which I think is key, agreed prior that I'm going to allow, after I own the property, I'm going to allow the seller to stay in that property for a period of time that we have already identified. So am I now a landlord?
That is not correct. And in fact, the contract that we use, the standard one in the state of Illinois, is a contract that indicates in one of the paragraphs, 35, that it is not actually a landlord-tenant relationship, and it does not operate as such. But it is correct that you are allowing me as a seller to stay in the property past our closing date. So I'm still giving you title to the home, but I am actually staying there in terms of possession.
Okay. And so you're staying there. I own the property. Do I have the keys to the property? Like, what are my rights as the new owner of this property as far as access is concerned?
The way that I've always seen it done, and I don't know if everyone does it this way, but keys are exchanged the day that I move out. So as the seller, if I'm staying for an additional week, we do another walkthrough so that you can, we'll talk about this in a second, but that's when I actually exchange keys with you, is when I'm officially out.
Okay. So this raises, as I'm sure for everybody, a bunch of questions, right? So let's just use this scenario again, where we're talking about 1 week where the buyer now owns the property. They're a new owner. The seller is living in the property. The buyer, the new owner, the buyer doesn't have any keys to the property, just the seller. So I'm gonna spitfire a bunch of questions to you about this. Okay. So am I collecting some form of rent or compensation as the new owner?
So let me start by saying on the contract, because everything's got to always be in writing, especially as attorneys, we want everything in writing. So on the contract, on paragraph 35, there are a bunch of terms that it outlines. For example, how much you're going to be paying, how many days are you staying, and then how much money is being put in what we call escrow, which I'll cover in a second. If you leave the escrow amount blank, which is the amount of money that stays from the seller's pocket from closing proceeds, one of the attorneys or the title company will hold that amount to the side, and it serves the purpose of paying out the rental amount. I'm just going to use that very casually, in addition to possible damages. When I'm moving out, after you come and close that property with me, I may cause damage. Maybe the stove stops working. Maybe the AC needs to be serviced because that also stopped working. Those are things that can come out of that escrow. The other thing that comes out of escrow is my 1 week's time we agree on how much money I'm going to give you. If you are a buyer with a loan, 99% of the time we see that being what we call PITI. That stands for your mortgage payment, principal, interest, taxes, and insurance. Let's say your monthly payment is $1,500. We take that, we divide it by 30 days or however many days are in that month, and we get a per day amount. That's what I pay you for rent for those days.
Unless otherwise negotiated, right? Because I've seen
Correct.
timeshares where people are paying nothing.
Correct. And there's situations where there's nothing. I see that typically when there's multi-offer situations and a buyer truly wants that house, they'll allow the seller to have that extra time at $0. The other way that I see it is if it's a cash buyer, for example, then the amount is just something that they negotiate, like you said. So everything is a contract, everything is negotiable.
Okay, so you had kind of said something about repairs that need to be done. So let's say during that week or whatever the time frame is, something does break. Is it the responsibility of the new owner or is it the responsibility of the past owner that's still living in the property?
That's a good question. So utilities, maintenance, et cetera, is all on the seller who's still in possession of that property. So that's why it brings me back to that question where you said about landlord-tenant. Most recently, we've had multiple situations with post-possession, and a few of my clients have reached out to me and said, well, I'm like a tenant, right? So if the AC stops working, that new buyer's buying that? And I said, absolutely not. You need to give it to them as if it's actual closing day, which means the condition of the property needs to be the same as it was when they put in that offer. So if anything has altered since then, unfortunately, you are responsible for it.
Wow, interesting. Okay, so I am now buying this property and I'm a little nervous because I'm not taking possession of the property yet, right? But do I still typically in a real estate transaction, for those of you that don't know, right before closing, you do a final walkthrough to make sure the property is in the shape that you're ready to buy it, that you agreed upon. So do I do this final walkthrough even though they're not out?
I'm a proponent of yes. You will talk to some agents and attorneys who actually do bypass that first walkthrough. For me, it's more of a cautious and precautionary step. I like when my clients, especially if I'm representing the buyers, I want them to go in, make sure that we're good. And if it's going to be a longer term possession, I definitely want you to do that walkthrough because we don't know what's going to happen in that 60 days. But if it's a shorter term, like a 1 week, I've seen people bypass it. I personally am not a fan of that though.
Okay, yeah, I agree. I would not be a fan of that either. And so then when the seller moves out, and because if I never saw the property as the buyer vacant, I don't know if there was something hiding underneath a rug or hiding behind the bookshelf or whatever the case is, right? So now the seller moves out and I see that there's this, for lack of a better idea, there's a huge water stain in the middle of these hardwood floors in the living room.
Sure. So that's a good question. Law is not always black and white. There's going to be some gray areas. So most recently we had a post-possession issue. A gentleman who was selling to my buyers had a piece of workout equipment, and the hardwood floor, when it was removed, had a hole in one of the pieces. And it was an older property in Chicago. So it had the very thin old wood that my client was so looking forward to keeping, but then there's this giant hole in it. So we did negotiate a $750 credit so that hopefully she could get that repaired. But that is not always the case when things like that happen. Sorry, I'm at proper title and they just they didn't think I was here.
Lights we have there.
I was too still.
Gotta move around.
But yeah, so to answer your question, there are times that attorneys will also put that in their attorney review letter. Like, hey, does the seller know of any instances or things that are being hidden by furniture? Please let us know. If it's a big enough concern, yes, it will get raised most of the times and it will get released out of an escrow. But of course, those escrow funds do not get released until everyone comes to an agreement.
And I feel like, cosmetic stuff, don't get me wrong. I mean, it takes money to fix those things. But I think one of my biggest fears would be, what if at the end of that week, now me as a buyer, I'm ready to move in, I'm ready. I got my trucks lined up. I'm ready to go. And the seller doesn't move out.
So that's a good question. And I have a story that we can share. It's going to be a brief one, but the contract outlines if you have a dollar monetary amount, then 3 times that amount is get put if you do not get out on the same day. A lot of post possession agreements, so will have their own amounts. So let's say we agree to $150 a day. If you're not out, I'm going to start charging you $300 a day. It's not necessarily 3 times the amount, but it's enough of a difference where most sellers want to get out. I currently have a contract where there is post possession. It was supposed to be for 45 days to give my client enough time to purchase another property. He has not been lucky enough to find, or at least he wasn't at the beginning lucky enough to find anything during the time period where we would have closed by July 3rd. Unfortunately, he needs an extra week because now we are under contract and we're closing July 10th. That being said, the post possession we signed at closing said $450 a day for anything past July 3rd. The story here becomes where my client and the other client decided they're going to connect on their own and come to terms. That is okay. But now it's become problematic because without the attorneys knowing that there was an agreement made that said, hey, we're just going to allow the 150 to slide for an extra week, the other attorney found out and was like, hey, we don't have enough in escrow for this. We didn't plan for this. So now we need you to deposit additional funds. And so we did navigate that properly by doing that. And I explained to my client that that is a very normal move. And I already called it before they even said anything because the $10,800 was just simply not enough. So now we're adding an additional $2,000 and it'll cover that extra 7 days so that everybody is happy. But there is risk involved with post possessions on both sides. Like you said, the risk on the buyer side is what if the seller doesn't move out on time? What are you going to do? Maybe you've got contractors set up. Maybe you've got things lined up and there's non-refundable fees associated. That's an issue. And then there's the risk of the seller's side because their money is tied up in escrow and that escrow cannot be released until all parties agree. So let's say that buyer does come in and that water stain was very visible during the inspection, but just missed. And they don't see it until that second walkthrough when they go to take finally possession of that property. Now they want money out of escrow. That can be, and this is where the attorneys get involved and we got to go back and forth and kind of try to figure something out that will make everybody happy. But the problem becomes when the parties don't agree, the funds get tied up. So we want to do everything in our power to avoid that.
Yeah. So everything in writing and keep the attorney up to date if you are to make any other type of agreement with the seller. Because what's interesting too about this agreement or that example that you just gave is typically in a real estate transaction, the buyer and the seller never communicate with each other. It all happens through the realtor or through the attorney or through whatever. Now that they're like staying in the place, et cetera, they now have each other's contact information and are able to communicate together. So that was interesting.
Yeah, I feel like in this situation, the buyer was like, I'm the owner of this property, right? I'm going to stop by. I'm going to look at the lawn. I'm going to, and my client happened to be there. They struck up conversation. It happened to come up that he needed the additional time. And then in retrospect, I found out. So I don't like those types of surprises as an attorney because I do want to protect you. And of course, my client now is like, well, that wasn't the agreement. I didn't know I'd have to put $2,000 extra on. Well, once the attorneys find things out, we need to properly protect our clients. And I told him, I would have done the same thing if I was that buyer's attorney.
And you said something about mowing the lawn, which just made me think too, if we're talking about somebody staying for a month, whose job is it to mow the lawn or here in Chicagoland, shovel the snow, shovel the sidewalks? Is it the past seller that's still living there is still responsibility?
Correct. All the maintenance, utilities, anything that you would do as a homeowner who truly owns that home, that's what you're taking on.
Move around so the lights don't turn off on you.
I'm just going to stay standing up. So yes, to answer your question, the seller has to pretend as if closing did not happen, essentially. The only real difference, and this is something that I defer to the home insurance companies for, you still need liability coverage for your personal property, especially because if something were to happen during that time frame, the buyers are not going to kick in on that. But everything else remains on the seller.
Oh, so that's interesting. I never even thought about the insurance. So does both the seller, the initial seller and the initial buyer both have insurance on their property?
That's a good question. So buyers, yes, especially if you're, any homeowner, especially with a lender, you're going to be required to have insurance before closing on that property. So your insurance kicks in as a purchaser the day you take title of that property. The seller, however, still is living in the property and has possessions inside that property. So they typically change their coverage to liability coverage, and the insurance agents are the pros in this, but they set them up so that they can have coverage during that interim.
Interesting. So there's risks for both the buyer and the seller, but it is really a ideal solution if the buyer has flexibility on when they can move in and the seller needs a little bit more time. This really is, as long as everything is in writing, this really is a good solution for that, right?
It is. And in the summertime, you're going to notice that it happens almost, I would say, I would say 1 out of every 4 transactions recently has been a post possession for me. Yes.
Wow.
And I would say the last 4 that I've closed were all post possession deals. So it happens. It happens very often. And the other reason why it's interesting is I have a lot of clients who do it on purpose, because in a market like this, especially in the summer, when it is a seller's market, especially because the inventory isn't high and there's too many purchasers, guess what? As a buyer, I would love to show up with cash in hand to go purchase your property. It's less risk for you. It's more, it's more attractive as an offer, and I'm probably going to win over the people that have loans that I need to wait 45, 60 days when I can close in 2 weeks. So a lot of my sellers like to have the cash in hand, and then they apply that towards a property to purchase in cash.
Oh, that's right. So the seller in this post-closing possession situation, the seller's receiving all of their proceeds from the sale of their home, even though they haven't moved out, right?
Correct.
Yeah.
Aside from that escrow holdback, that is the only amount that's being held back. Let's call it $10,000. You were supposed to make 200. Today you walk away with 190 grand. 10,000 stays in escrow. You'll get that back theoretically later, minus your cost of living.
And you haven't even moved yet.
Correct.
So I know that if I'm a buyer and I'm getting a loan on a property that I'm purchasing, I know that I agree to take possession of the property within most loans 60 days, right?
Sure.
To make it, that's why I'm getting it as my primary residence. What happens if in this scenario the seller needs 90 days?
So, I mean, it's doable. I've had long post possessions, probably only a handful of times in the 10, 11 years that I've been doing this. I just don't love it as an option. I typically tell my sellers it's a lot, there's going to be a lot of risk. You're going to have to put a lot in escrow holdback. You don't know what type of maintenance is going to be deferred at that time during your time period. Like I said, the AC going out, that just cost us 5, 6 grand last year to replace. So it could be very, very pricey. But I completely understand that if someone doesn't have anywhere else to live, or if they have a lot of property and they don't want to just put it in storage and then have to move it again, it's more for convenience, if anything. But as a buyer as well, it could be very risky. The one thing I will note for post-possession, and I find this interesting, is there are attorneys who do it differently. Although the contract typically calls that the escrow holdback will be held, and then from there you will deduct your per day and your damages, if any. That's the way I like to do it, because let's say you and I have an agreement that you're going to stay in the property for 60 days, but you move out in 45. If I've already paid you, which is what some attorneys do, they will pay the rental portion up front. And I understand why they do that for longer possessions, because sometimes the buyer needs those funds so that they can cover the mortgage payment for a house that they're not even living in yet. And it's completely understandable. However, if I end up moving out 15 days early and I've already paid you, it's harder to go and ask for money back than it is to do it the way that I have always done it, which is keep the money in escrow. Once I'm out, you will get that money. The other way of doing it for long-term post-possessions, you could put this in agreement, because again, everything is negotiable. We could say that you're going to stay in the property for 60 days, but on day 30, you're going to get me my 30 days of per diem out of escrow. So at least release a portion of it to me. I can utilize that to pay my mortgage. Then we'll do it again in 30 days. And at that point, if you do end up leaving 15 days early, you're good. I'm good. Everyone's happy.
Y'all, wait, hold on, Vicki. I gotta get on my virtual soapbox. Y'all, this is why it is so important to use a real estate attorney for your real estate transactions. Just because someone's an attorney does not mean they know all of this stuff that Vicki just brain dumped on us in the last 19 minutes. So please, when you are doing a real estate transactions, just because somebody's like an attorney and they're like, oh, I can do that for you. No. get somebody that does real estate law all day, every day, like Vicki and her firm, so that you can be covered, because this is just one of like 400 topics we could be talking about. She just mentioned this one paragraph inside this contract about post-closing possession. So you can imagine how many other things that you could brain dump on this right now. So please use a real estate attorney for your real estate transactions. Okay.
I do agree with that. It makes things go much smoother. And then, like I said, when there are issues, if you're a real estate attorney and you do hundreds of transactions a year, it's going to be more likely that you and I can pick up the phone and resolve something very easily, sometimes without clients needing to get stressed out at all. And we've already beat it to the punch. So unfortunately, if you don't have the experience, just like I don't have the experience for litigation, I'm not going to go ahead and take that on. That's something that I will refer out. So I do agree with that. 100%.
Yeah. It's like, don't have a heart surgeon do your brain surgery, right?
100%. Yes.
Y'all, this is Vicki's contact information is also in the comments if you're watching on Facebook, Instagram, LinkedIn, YouTube, wherever you're watching, right down here below. Give her a call if you have any questions, not just about post-closing possession, but about any of your real estate transactions, her and her firm right here.
Thank you so much. That is my cell phone number, and I'm on it, embarrassingly, I'm going to admit, all the time. So feel free to reach out whenever you guys need something.
Thank you, Vicki. Thank you so much for being here this morning. Thank you for letting me tap into your brain.
Of course.
Very enlightening. It's really amazing after doing this for years. I still learn new stuff every time I talk to any real estate attorney about anything. So thank you. This was really enlightening.
You're very welcome.
All right, y'all. We'll see you next week. Be kind to each other.
Okay, bye-bye.